Good morning. Glad to see so many of you here. I'm going to introduce the four panelists. I'm not going to introduce the four panelists. You have, except by name, you have the descriptions of their work and their professional lives on your program. I am going to change one thing about the order. I'd like Pradine to speak last, although on the program she is not last, because this is a panel full of critical approaches to specific elements of the topic of this conversation, of this conference, and I think it would be nice to have the presentation which is about the future and about possible positive developments to come at the end. So our first presenter will be Judith Greene from Justice Strategies. I also will be kind of strict about the time. I think if we each spend 15, 16, if you each spend 15 or 16 minutes, and then we have some time for not only my brief comments, but also some Q&A. Thanks very much.
Would you like to sit here?
Chuck one.
Morning. Watching Dora talk about her time at ICE, and can I sit down? Thank you. Watching Dora talk about her time at ICE and ruminate on making change and what is needed, I think sort of lifted at least my sights. But here I am to talk really about the heart of darkness, the politics and practices developed in the state of Arizona, where Dora, being in Arizona but not of Arizona, was one of the few bright lights during a very fractious period of time. Arizona, emerged in the media in the last year or so as the sort of corrosive and abusive end of what it looks like ICE operations, detention, and the infusion of those issues, those controversies into the criminal justice system itself. I want to say just a little bit about Arizona by way of background, talking about something that hasn't been looked at much by the national media. We know a fair amount about the impact of Arizona's harsh immigrant enforcement practices on immigrant communities. We don't know enough, I think, about the impact of all that turmoil on the criminal justice system itself. So that's what I want to talk about. Arizona, of course, is one of the toughest criminal justice jurisdictions in the country. It's the incarceration capital of the West. It's the fourth highest among the 50 states, however, fiscally conservative they are, in the percentage of their total general fund budget that's spent on corrections. It's also historically been a trendsetter for all the wrong ideas. The first state-level supermax prison constructed for that purpose was constructed in Arizona in the mid-'80s. Arizona was one of two states to, re-pioneer or reinstate the system of chain gangs in the state level, as well as the famous chain gangs that Joe Arpaio operates in Maricopa County. So it shouldn't be surprising that the state has become sort of the leader in the development of the worst practices in terms of dealing with immigrants and undocumented people. The Arizona Laboratory, the Wall Street Journal calls it a learning laboratory, provides us a window to see not only how the federal agencies who are authorized to handle immigration enforcement and detention can traverse the politics of local democracy and poison the system of criminal justice. At the same time, the sharp contours of Arizona politics have shaped the national debate on immigration issues, as well as many aspects of federal policy and practice. Again, just a little bit about the strategic site. Immigration in Arizona is the strategic site for the white supremacist movement in that state. The national press coverage that made Joe Arpaio the poster child of immigration basically misrepresented what had been going on in Arizona for some time with his complicity. Actually, some years back, he mouthed the usual law enforcement platitudes about how, local police should not enforce immigration laws because it destroys trust between the cops and the communities. But he jumped on board once a caravan was created by Russell Pierce, who now some people know his name, but until he was recalled last November, many people did not. Russell Pierce was the godfather of Arizona's immigration experiments and stood really in contrast to Arpaio, who basically incites anti-immigration fervor for political popularity. Russell Pierce is a true believer and has many white supremacists among his base. Stepping back quickly, let me remind you that, it was the home base back in the 60s of the presidential campaign of Barry Goldwater, who campaigned on a states' rights platform, voted against the Civil Rights Act of 1964 and was 1964 and was the first Republican to sweep the South. Louisiana, Mississippi, Alabama, Georgia, and South Carolina elected Barry Goldwater in 1964. Thankfully, the other states did not. First time I set foot in Arizona was in early 1988. I was doing some work with the court system down there on intermediate sanctions, having a meeting with the presiding judge in Maricopa County, Michael Dan. And that very day, a judge named Tom O'Toole was managing a grand jury that was indicting Evan Meekum, then governor, who had been elected governor on a platform of, among other things, abolishing Martin Luther King holiday. So back to Russell Pierce. His anti-immigration crusades and his extremist views on immigration were normalized in Arizona. He campaigned to bring back Operation Wetback and drafted in 2004 Proposition 200, which was a sweeping initiative that was approved by 56% of the state voters, including 47% of Hispanic voters that year, requiring that people who register to vote or apply for public benefits prove that they were citizens. It also turned state employees into immigration police by requiring them to report suspected illegal immigrants. If they failed to do that, they could be put in jail. Prop 200 had political and financial backing from many national hate groups, $350,000 from $500,000 from the Federation for American Immigration Reform. Now, it became a contentious issue between Pierce and his followers and Arizona then Governor Janet Napolitano, who campaigned loudly and long against Prop 200. And once it was enacted, she did pretty much everything she could to try to challenge it procedurally and damp it down. In fact, Pierce accused her of her efforts to amounting to a backdoor veto. But her principled opposition to 200 cost her precious political capital. And she responded by changing her focus, turning the political focus from public benefits to law and order. She declared a state of emergency on the immigration problem, inviting ICE to patrol both the borders and the interior city of Phoenix, along hand in hand with Arizona's Department of Public Safety. And approached Secretary Chertoff, then Secretary of the Department of Homeland Security, for one of the first authorizations under Section 287G, the devolution of police powers to state and local authorities. Plans were laid to deputize 2 state agencies. one being the Department of Corrections, where Doris Schreio was, and that deputized correctional officers to initiate removal proceedings against people who were thought to be eligible for removal. The idea largely was to, reduce population pressures and save money. But the other power was given to the state police, and Napolitano had told Chertoff in a letter requesting these powers that local law enforcement officers often come into contact with large numbers of undocumented aliens during routine traffic stops, foreshadowing, I think, practice in the state once 287G became institutionalized in the Sheriff's Department. So the public target of Proposition 200 was the immigrant who wanted to vote or receive welfare benefits. Napolitano basically had shifted the crosshairs to the lowest common denominator, which is now, I think, nationally pervading ICE's explanation of their targets and their priorities, the criminal illegal alien population. While she was strategizing with the feds to implement 287G, the legislature raised the ante. Flirting with the Constitution's limits, they enacted the first state-level international human trafficking law in the country, making smuggling of human beings for profit or commercial purpose a state-level Class 4 felony. This was coming 1 year before the nationwide spike in state-level immigration legislation. Arizona was blazing the trail in a movement to devolve immigration controls. Now, Maricopa County is not a border town, but a newly elected Maricopa County attorney, the prosecuting attorney in that county, who had campaigned on a pledge to end illegal immigration, eagerly politicized the law. While legislators, Kirsten Sinema, for example, thought they had enacted a traffic law that would be similar to the federal law. Thomas came up with his conspiracy theory of immigrant smuggling, which is to say that people who were smuggled or brought across the border by coyotes or traffickers were guilty of conspiracy to smuggle themselves, and therefore were charged with a Class 4. And Sheriff Joe, before he even got his 287G powers, started running sweeps. The first sweep brought in 54 immigrants. They were charged with a level 4 conspiracy to commit human smuggling. Thomas offered them pleas to a Class 5 felony, probation with the condition they agreed to leave the country. Most of them took the plea bargain, although pleading guilty to any level of felony made it impossible for them ever to gain legal status in the United States, which was part of Thomas's strategy. The cases were contested by the defense bar in Arizona, and Judge O'Toole, the guy I had mentioned before in relation to Meekum, his courtroom became the forum. The defense lawyers argued that the law was preempted by the federal Constitution and that this conspiracy theory, smuggling yourself, was not legally possible and contradicted the legislative intent. The judge overruled the defense's arguments, basically, but then made a distinction between people who simply paid to be brought across the border and people who had gotten a cut rate on their travel by agreeing to drive the van or whatever. So he dismissed the cases that came before him of simply coming across the border. But even in the cases where people had done something towards the conspiracy, he ruled against the prosecutor on the basis of evidence, and he said the defendant's confessions couldn't prove guilt. Sheriff Joe, oh dear, 2 minutes, I better move along. In the following year, Russell Pierce wrote another state-level immigration bill This one, Proposition 100, he wrote it to go on the ballot, and it was approved by 78% of the state voters, added immigrants to the list of criminal defendants who cannot apply for bail. Proposition 100 amended the state constitution to create a new no bail category for serious felony offenses as prescribed by the legislature if the person charged has entered or remained in the United States illegally, and if the proof is evident or the presumption greatest to the present charge. This set off total chaos in the courts, judges, fighting with prosecutors, and complicated pressures and litigation around whether or not people who were brought in allegedly having illegally crossed the border had any rights to a hearing, an adversarial hearing, because bail setting happens at an initial appearance at which there is no defense lawyer present. I won't go into the details. The Chief Justice of the state, Ruth McGregor, tried to implement some new initial appearance procedures that granted people right to an adversarial hearing, and Pierce responded with a cleanup bill which essentially lowered the evidential standard for determining immigration status to probable cause, required that the determination be made at the initial appearance, and specified that if a police officer said the person had illegally crossed the border, that was adequate evidence. What more to say? Well, Joe Arpaio's involvement with the 287G powers that he was given in 2007 quickly became fodder for national media coverage. And so I'm going to assume that most of you know that the controversy down there erupted in large public demonstrations. The organization headed by Salvador Ressa was picketing Joe's office at the Wells Fargo Bank on a daily basis for well over a year. There were marches and demonstrations that attracted people from all over the country. Arpaio kept raising the ante, repeatedly sweeping up immigrants, and he also used his powers in order to pursue people under the conspiracy theory. So by October 2007, more than 1,000 people had been swept up and prosecuted under that theory. I was going to have a lot of fun talking about how the protests really rose to the point where Russell Pierce found himself facing a recall election, and I assume most of you know that he was removed from office last November. You probably also know that Sheriff Arpaio ultimately, through investigation by the U.S. Department of Justice and an action by Janet Napolitano, his agency's 287G powers were revoked. But I think it's important to see Arizona as a cautionary tale, because by targeting criminal illegal aliens as the lowest common denominator of immigration enforcement, the political leaders of the state set off a domino effect which has transformed the fabric of law enforcement in the criminal justice system in local democracy. Arizona-style crimigation inflamed the national debate and brought calls for comprehensive immigration enforcement to a halt. In the state, every element of the criminal justice system has been mobilized to wage a relentless campaign to expel immigrants from the state. The basic roles and functions of officers on the street, in the courts, in corrections have been distorted and stretched to the breaking point. The legitimacy of the entire criminal law and justice system is badly tarnished because fears of polemigra pervade the Latino communities across the state.
Thank you very much. This was a very rich paper, much of which she wasn't able to get to, so maybe some of you would like to be in touch with Judy to look at the... Oh, sorry. This is a very rich paper, which she couldn't get to all of it, and I urge you, if you're interested in this subject, to be in touch with Judy to get the full paper. Now, Juan Pedroza is going to speak. He is from the Urban Institute, and his research focuses on the implementation of secure communities. You can...
Okay. Can I advance my own slides from up here using this? All right. Using this. This works great. Okay, so it is now about 10:23. So 15 minutes from now will be 10:38. I will try to stop. My name is Juan Pedroza. I work at the Urban Institute. I've been there for 5 years. If you want to get in touch with me, my contact information is up for the next couple of months. Then I'm off to graduate school. If you're interested where, let me know. Not sure yet. So this is based on some initial work that I'm doing that is modeled, if you're familiar with a paper from a few years back from Stanford Law Review called Refugee Roulette, where the authors find that asylum decisions have as much to do with where your case is processed and who the judge is as the facts of the case itself, which grates against our sense of justice when you hear something like that. The evidence I'm presenting today doesn't actually rise to that level. I am in the process of testing some of those claims, but I do want to present some descriptive findings that I think are interesting nonetheless. A little bit of background. Been at Urban for a while. I was born in Guanajuato, Mexico, Jalisco actually, raised in Guanajuato, and I was in Chicago for a long time, for a decade. And in that time, I happened to be in the custody of Cook County, Chicago Police Department. And at that time, if secure communities had existed, my fingerprints would have been run. Wouldn't have been a hit on much of anything, but I might have been held to try to figure out where exactly I was from. Even though I was never convicted of anything, might not be here today. I was not authorized then, I am authorized now. So that's my background, just give you a little bit of context on why I'm interested in some of this stuff and what kind of moves me. Overview, I will do just a very, very, very quick immigration enforcement background. I am actually going to assume a fair amount of knowledge, which I'm hoping is a fair assumption, given that this is an immigration conference. I can't go into all of the terms. I will be referring to secure communities as SCOM. I will be using the word removal to refer to deportation, removal, voluntary departure, and returns as one. I will be using the word removable to refer to those foreign-born people who are removable, as I was. I will use the word alien, mainly to refer to folks with an alien number who might be legal residents as well as unauthorized, quote-unquote, aliens. I will use the word submission and match to refer to SCOM. Submissions are your biometric fingerprints that are run through the system, and a match is when there is a hit in a federal database. Just a little bit of background there. My research questions will be pretty discrete. Where are SCOM removals concentrated? Which places have the most targeted SCOM enforcement? Where are the highest rates of removal or deportation across the US? How has SCOM changed over time? How does SCOM look across regions? And finally, some initial implications that I'm very, very much still working on. So, I'll try not to look behind me because I find that annoying, so I've got my phone here, thankfully. This is from a report by the Congressional Research Service. I encourage everyone to pick up and read if you haven't already. It's by Mark Rosenblum and Willem Kandel. They have this neat graph that gives you a sense of who is removable. Well, if you're unauthorized, you're removable. And this isn't exactly to scale, but it's mostly to scale. It also shows you that you can be a criminal alien, but not removable. This is someone who might be a legal resident who commits a fairly low-level crime, not an aggravated felony, not a serious crime, is a criminal alien, but is not removable. Then there's also removable criminal alien. You commit an offense that rises to the occasion where you've now put your legal residence in jeopardy. And finally, aggravated felons. And if you're familiar with the long list of aggravated felonies, it's actually a much more ominous sounding label than it actually is in every case. And the reason why that circle is so large is the long list of aggravated felonies that keeps growing. I find that chart useful. So now some numbers from that same report. Back in 2004, the biggest players in the interior immigration enforcement arena were really the Criminal Alien Program, CAP, all the way on the left, and NFOP, the National Fugitive Operations Program, all the way on the right. And you can see the number of arrests there. It's about 10,000. Fast forward to 2010, ESCOM is now on the scene, and number of arrests there are greater than both NFOP and the 287G programs that we heard about in the last presentation, combined. It's bigger than both of those combined. ESCOM is still not bigger than CAP, but might get there someday. They're kind of the two largest interior enforcement programs. What do offenses look like? You might wonder, okay, now we know a little bit about removable aliens. We know a little bit about what the interior enforcement programs look like. What about the crimes themselves? You might be familiar with this typology that separates crimes into level 1, 2, and 3, and then other. This is exactly the typology that ESCOM uses to report its statistics. They do report convicted level 1 crimes, level 2, and level 3, and then they also report separately for ICE fugitives, people who've been removed before and find themselves in custody again, and then entered without inspection, or what I like to call it, the wrong place at the wrong time. Maybe they committed a crime for which they were never convicted. Maybe they committed a crime for which they were convicted, but for which there is no record in the federal database. But it definitely includes EWIs. You were just at the wrong place at the wrong time. And I think for the most part, level 1 crimes are what you would expect. Murder, rape, those kinds of things. We can quibble a little bit about whether or not they're exactly in the right place. For example, I think commercial sex offenses should be much higher than level 3. I'm not sure that traffic offenses always rise to the level of always being level 2, but for the most part, I think we can agree. I think. Back to the CRS report before moving on to my own work. You should know that ESCOM and 287G over time have gotten less and less good at concentrating their energy on those level 1 crimes, even though when they're sold to the public, that's how they're sold. They're sold as a way to get the most serious criminals. And those are just some percentages. And you can see level 1 percentage of all arrests going down over time in both programs. So that's some background. All of this we already know. And if I stop now, I would be contributing nothing. What do I want to contribute? Well, where are ESCOM removals concentrated? Which places target the worst offenders best? Which places have the highest removal rates or rates of deportation relative to the size of the unauthorized or non-citizen population? And are ESCOM removals getting more targeted over time? That seems important. Which regions have more targeted enforcement and which regions have less targeted enforcement? I will do my best to answer all those questions. A minute over so far. Most of the country reports very, very limited ESCOM activity, as you would expect. Unauthorized and removable aliens are not evenly distributed across the country. In fact, 4 out of 5 deportations are concentrated in just a few states, and I've listed them there. 34 states report less than 1% of removals each. So you could find easily 34 states where less than 1% of all removals happened in that state, emanated from that state. 9 states account for everyone else. That's just kind of a reality check of where folks are. ESCOM criminal removals, I would be remiss if I didn't say that 26.8% of all national removals correspond to what ICE says is a convicted level 1 criminal. 26.8%. I'm going to come back to that figure. You can kind of keep going down. You can see level 2 and 3 up behind me, all the way down to fugitives, visa overstayers, and entered without inspection. You can see those numbers there. Some of the following slides have a lot of tables. I'm not going to go through every number or bore you with the details. I'm going to try to hit the highlights. Here, what you should notice is Oregon and Utah combined, if you add up the total number of biometric fingerprint submissions, it's about 260,000. For those submissions, what did they get? They got about 940 level 1 removals. They were able to find 940 of the worst of the worst. That's about 1 in 3 removals. That's actually really good. That's actually the best in the country. Those are the top best states at focusing on level 1 removals, and that's the best they can do. At the bottom of that table are the worst 8. And I defined worst 8, I didn't just choose 8 as an arbitrary number. I actually said who's above the national average, and those are the top 8, and who is below 50% of the national average. So 13% and under. So look at Missouri and South Carolina, and I chose those deliberately. They submitted twice as many biometric fingerprint submissions as Oregon and Utah did, about 455,000. What did they get for all of those submissions? Twice as many. They got 189 level 1 criminals, compared to 940 in the other 2 states. Do you see kind of the imbalance here? That's 1 in 10 removals is a level 1 criminal in South Carolina and Missouri, and I picked those for a reason. Notice that Arizona is way high on the list of targeted. They're not off the hook, don't worry. Because on the next slide, if you actually look at the deportation rates, and here I'm just following very simply what some other folks have done, which is take total number of removals in an area, and then you take the estimated number of unauthorized or non-citizen population, you just do a very basic division, and you get a rate. Turns out that Arizona is really at far and above the quote-unquote best at keeping a really high deportation rate going. So even though it's relatively targeted compared to other states, the deportation rate is really, really, really high. And that holds if you look at non-citizens as well. So that answers my second question, where are these deportation rates highest? So if you live in some of the states that are higher up on the list, I hope you have a lot of good luck and some good sense and stay out of trouble, and a whole lot of good luck, because you're going to need it more in Arizona than you'll need it in Tennessee. So my next question, I believe, is over time. Yeah. Over time has focus on level 1 crime become more targeted? Has it become better? Well, I already showed you from the CRS report that it hasn't, but I just wanted to reiterate. And there's 2 lines on that graph. One is the level 1 crimes, and you can see that line over time. At the bottom, the blue line. And then the line on top adds level 1, 2, and 3. Now, if secure communities, SCOM, was becoming more targeted and better and more efficient and more focused on those folks that we all agree should be identified, you would expect to see some sort of slope trending upward at least a little bit. And there's not really much of that going on. And from what I've seen, I think it's due to the design of the program. You're starting a lot of new communities every month, every week. And actually 4 out of 5 counties in the entire country as of Tuesday now have SCOM live. Look at it another way in terms of over time. The jurisdictions, there are 14 jurisdictions that have had SCOM from the earliest days in 2008. Of those 14 jurisdictions, they manage to focus 81% of their attention on a convicted criminal of some sort, 1, 2, or 3 level. Go down to the next line. Of the 88 jurisdictions that have been around since 2009, it starts to slip to 74. Then it slips to 71% for those that have been around since 2010. And the most recent entries into the SCOM world are the worst at targeting their enforcement. And we can kind of debate what this means and what we might expect as SCOM keeps getting rolled out and as SCOM programs mature into the future. And my last question, by region, where are the differences by region in terms of SCOM? Just look at that second to last line of level 1 removals as a share of all removals. The most established destinations being California, Texas, Illinois, New York, although I will say Illinois and New York don't actually have a lot of activity going on. It's mainly Florida, California, and Texas. 28.3% of all removals are for level 1 crimes. That's a little higher than the national average, Same for the West. And once you get past that, the South, the heartland states, and that definition of the heartland follows some other work that looks from the Dakotas down to Arkansas and Oklahoma. The Midwest, all the other states in the Midwest that aren't included in that definition. The Mid-Atlantic and the Northeast. One asterisk on that last one, there are a lot of states where ESCOM has not been activated in the Mid-Atlantic and the Northeast, so that might explain why they're so far below criminal removals all the way down to 52%. But anyways, I want to point your attention to the South, the Heartland, and the Midwest as the program stands today. Those are the places that seem to be having the hardest time spending time and energy on level 1 criminals. It is 10:38. I won't go through my implications except to say the second one. If enforcement doesn't become more targeted, are these priorities that ESCOM has set up legally, technically, are they actually a dam? You know, we will stop once we've identified all level 1 criminals. Is that what we're talking about? Or we won't stop until we will stop when we get all level 1, 2, and 3 criminals? Or is it more of a water mill where you've got this wheel kind of turning, and as soon as one bucket's full, you just kind of go to the next one to fill up the beds and fill up the system? Which is it? And I think that there's debate for that. I'm done.
Now we have Michelle Waslin from the American Immigration Council, who is going to talk about driving while criminal while driving. Driving while immigrant. I knew I would get it right eventually. Thank you.
Good morning, everybody. We all know that driving, or being driven, has become an increasingly risky activity, and it has a higher probability of deportation for unlawfully present immigrants. And as the border has thickened or become omnipresent, traffic enforcement has come to play a more prominent role in immigration enforcement throughout the interior of the United States. So I've been looking a lot at the same data that Juan has looked at. I've been looking at the statistics and heard a lot of anecdotes about unauthorized immigrants being identified for deportation through traffic offenses. And I started thinking, how exactly did we get here? This is a very personal question to me. I arrived from my job in Washington, D.C. exactly 1 week before 9/11. And as a policy analyst and an advocate, I've been working on these issues of driver's licenses and the devolution of immigration enforcement to states and localities for over 10 years now. And so this is really a work in progress, and I look to all of you to help guide me as I try to really hone in on this and reach some conclusions. But like I said, I have seen both of these policy issues, the driver's license restrictions and the devolution, over the last 10 years or so. There's a growing literature on the devolution of immigration enforcement to the states and localities, and there's a literature on the denial of identification documents and what it means for non-citizens' identity and membership. But I have not seen a lot written that really combines these two issues and the result for law enforcement agencies and for immigrant communities. Beginning in the 1990s, but really more frequently in the early 2000s, states have restricted driver's licenses to lawfully present immigrants, meaning that unauthorized immigrants must refrain from driving or risk being caught without a driver's license. And in this way, states have taken this regular daily activity, driving, and criminalized it, putting millions of unauthorized immigrants in a position where they violate a state law if they drive. But that really didn't matter too much until local police increasingly partnered with federal immigration law enforcement agencies through official programs like the 287G program, the CAP program, and the Secure Communities program that we just heard about. So now the fact that immigrants can be arrested and convicted of driving without a license exposes them to law enforcement in a way that they had not been previously. And now new state immigration control laws, such as Arizona's SB 1070 and Alabama's HB 56, are really making driver's licenses the linchpin to enforcement. As a result, there's a lot of anecdotal evidence that unauthorized immigrants are fearful of driving. They're not driving. They're not going to the grocery store. They're not going to work. They're not driving their kids to school. And I even saw a story where they're taking taxis more frequently to avoid driving and deportation. So there is evidence, we know from the numbers, that unlawfully present immigrants are being identified for deportation by ICE after being arrested for driving without a license and for other traffic violations. A recent report by AILA, the American Immigration Lawyers Association, examined 127 cases that they had gotten from their members. And of those 127 cases, in 66, ICE or CBP had initiated proceedings against individuals because of minor traffic violations. According to this report, drivers were pulled over for making right turns on red lights, U-turns, or other improper turns, for having broken brake lights, tail lights, or lights over their license plates. And once stopped, the most frequent basis for an arrest or citation was driving without a license or having an expired license. Another report found, this was a report from May 2008, 83% of immigrants arrested in Gaston County, North Carolina under its 287G program were charged with traffic violations. And DHS's own statistics show this as well. In fiscal year 2010, nearly 31,000 convicted criminal aliens were removed, and they had criminal traffic violations listed as their crime, according to DHS statistics. Criminal traffic violations was the third most common category of criminal conviction, only after convictions for dangerous drug offenses and criminal immigration violations. And then very recently, TRAC obtained data from ICE on all individuals that were in ICE detention on one date, October 3rd, 2011. And so this data included both the threat level 1, 2, or 3, as we saw in the slides, and then it looked at the individual's most serious criminal conviction. And surprisingly, simple traffic violations were the 13th most frequently cited level 1 charge. And overall, traffic offenses were the second most frequent, most serious charge listed for all detainees with a criminal conviction. I think we need to look a lot more at these numbers because it seems very strange that simple traffic violations show up so frequently in level 1. So I'm not going to go through the history of driver's license restrictions, but basically in the early and mid-90s, a couple of states had already in place legal presence requirements. So California and Colorado were among the earliest states to have those. Restrictionist organizations promoted these restrictions early on. FAIR was actually a key supporter of California's restrictive legislation in 1993. And this was really one of their first ventures into this idea of attrition through enforcement. This was a way to deter unauthorized immigration and deny those that are here access to employment and other opportunities. So in 1999, FAIR testified before Congress as to the importance of regulating the issuance of driver's licenses, and FAIR identified this as a vital piece of documentation for even routine daily activities such as cashing a check. So unauthorized immigrants needed to be denied driver's licenses. I was surprised to find that IRA, passed in 1996, actually had a provision, Section 502, that permitted states to conduct pilot programs to determine the viability, advisability, and cost-effectiveness of the states denying driver's licenses to unlawfully present immigrants. I found no evidence that any of these pilot programs were actually undertaken, and there was no report to Congress, as was called for in the legislation, but I thought it was really important to note that restrictions to driver's licenses were included in IRA in 1996, and of course this is the same law that created the 287G program. So they were in the same bill, but not really tied together. Now, before 9/11, most states, even though they didn't have legal presence requirements, they had de facto restrictions on unauthorized immigrants getting driver's licenses, mainly because they required a social security number. So that meant that even though there was no strict legal presence requirement, undocumented immigrants couldn't get them. But then after 9/11, and of course the revelations that several of the terrorists had obtained driver's licenses, nearly all states instituted legal presence requirements. And the rhetoric surrounding this debate became decidedly about national security. While it was the same outcome that the restrictionists had been calling for years, the rhetoric really created the space for states to act quickly, and most states did. However, it's important to note that proponents of driver's license restrictions were not making the direct link to immigration enforcement. While the lack of a license would certainly prevent unauthorized immigrants from certain activities, including committing acts of terrorism, no one was really openly arguing that the lack of a license would lead to an arrest, which would lead to deportation. So as with these driver's license policy changes, the role of state and local police agencies in federal immigration enforcement has been expanding slowly for years as well. And then the terrorist attacks of 9/11, along with increasing frustration and anti-immigrant sentiment, really resulted in unprecedented involvement in federal immigration enforcement by LEAs, law enforcement agencies. And the expansion of the role of LEAs developed parallel to, but again, not explicitly connected to, driver's license restrictions. The attacks of 9/11 ignited the debate over the authority of state and local police to enforce civil immigration laws, and the federal government referred to them as force multipliers. As a result, we saw expanded use of the National Crime Information Center for immigration enforcement purposes. Then we saw the 287G, even though it had been passed in 1996, really wasn't used for the first time until after 9/11. And now, of course, we're seeing the expansion of the Secure Communities program. So this has expanded the role of LEAs and really linked traffic offenses to immigration enforcement. Again, while the same group of people, the restrictionists, tended to be the proponents of both of these policies, there are few instances when the explicit link between denial of driver's licenses or other traffic violations and immigration enforcement was made. The advocates knew this was going to happen, but nobody was really saying this outwardly. To put it more clearly, no one was explicitly arguing that we could significantly increase deportations if we allow cops to arrest people for driving without a license and then pass them along to ICE for deportation. There was one notable, very notable exception, and that's Chris Kobach. He, of course, was in the DOJ, and now he is working with states on state immigration control laws. And so he has made the link, kind of, in his formal statements and what he's written, but he hasn't really made it explicitly. Both driver's license restrictions and the increase of the role of state and local cops are important elements of their attrition through enforcement policies, but they're not linked together. But Kobach has linked the two issues. In 2003, Kobach testified before Congress on the CLEAR Act, and in his testimony, Kobach concluded that the most effective solution to the problem would be to make eligibility for federal highway funds contingent upon states denying driver's licenses to illegal aliens. That provision was not in the CLEAR Act, but it was in the Senate version of the bill, the Homeland Security Enhancement Act of 2003. I want to talk a little bit about the expansion of the NCIC database. As you know, law enforcement officers can search NCIC during any stop and instantly determine whether the individual in question is subject to any outstanding warrants or otherwise wanted by law enforcement. And after 9/11, NCIC was expanded to include a couple additional categories for immigration violations. Now, in 2004, Kobach again made a link here. He testified before Congress connecting traffic offenses in the NCIC. He said, when you cast that wide a net and you basically are looking at everyone who gets a speeding ticket, you can achieve real results. The connection between NCIC and traffic violations is clear. A law enforcement officer can search NCIC during a traffic stop to determine if the vehicle in question is stolen or if the driver is wanted by law enforcement. Through their access to NCIC, therefore, LEAs obtain information regarding potential violations of federal immigration law and thus have the ability and the authority to arrest and detain individuals if they are in the NCIC. So it was argued that one of the 9/11 terrorists had been stopped for traffic violations, and if the police had access to information that he was out of status at the time, he could have been taken by immigration authorities, and 9/11 might not have happened. In this way, traffic violations could lead to deportation, but again, only if there was information about that person in the NCIC about immigration violations. It doesn't mean that the non-citizen would be made known to DHS through the traffic violation alone. The person would be turned over to ICE only if there was evidence of an immigration violation in the NCIC. But more recently, with the expansion of 287G, secure communities, it's really changed the quality and quantity of the involvement of LEAs in the enforcement of federal immigration law. And while this has led to the deportation of non-citizens who have committed serious crimes, it's also the case, as we saw, that local police arrest non-citizens who pose no threat to public safety for relatively minor crimes, including driving without a license. And because under this model, LEAs are responsible for channeling immigrants from the criminal justice system into the federal immigration enforcement system, and because these LEAs have their own local interests, their own priorities, there's a strong potential that non-priority non-citizens, people who haven't committed a serious offense, are going to be channeled into the immigration enforcement system. And it really opens the door to using traffic violations as a way to do that. So, obviously when a driver is stopped for a traffic violation, and this might happen legitimately, or it might happen because of racial profiling, because of pretextual arrests, the first thing that happens is the officer asks that person for a driver's license and registration. And if the driver can't produce a driver's license, that signals the officer that there may be an immigration violation. So NCIC can be immediately queried. Even if the NCIC produces nothing, the police can arrest the person, and upon booking, those fingerprints will go through secure communities to ICE. Even if there's no hit within secure communities, a jail model 287G officer or a CAP officer could interview that person and put that person into deportation proceedings. So in other words, there are multiple and overlapping mechanisms for translating a traffic violation into immigration proceedings. Just real quickly, I want to talk about recent developments, because I think it's very recently that we're seeing this direct link being made between driver's licenses and deportation. So, for example, now states have passed laws that explicitly say that they won't recognize the driver's license from states that don't have legal presence requirements. Another way, of course, is through traffic checkpoints that are designed to allow police to check people's immigration status. I've seen it more and more written about this, that communities in many states have reported these sobriety checkpoints, but they put them in places where immigrant communities live or go to church or go to school. There was a report just last week about Escondido, California, that has a particularly harsh policy, and they identify approximately 10 unlicensed drivers for every one drunk driver. There are also the laws, as Judy said, about transporting and trafficking. That, again, makes this direct link with traffic offenses. Oh, shoot. And then in Alabama's HB 56 in Section 18, it says that every person must carry a driver's license when driving a motor vehicle. And if the officer is unable to determine that person's status in any other way, they have to take them to the nearest magistrate, and that person has to be considered a flight risk, and the police have to determine the person's status with ICE. There's another law in Congress right now, the Scott-Gardner Act, which amends the INA to add DUI offenses to the list of offenses where non-citizens are subject to mandatory pre-hearing detention. It would basically make 3 DUIs an aggravated felony, and it creates a new provision that that requires LEAs to verify the alienage and immigration status of all persons arrested for DUI if the officer has reasonable grounds to believe the person arrested is a non-citizen. So if this were to become law, Congress would, for the first time, require all LEAs to investigate immigration status at time of arrest for a traffic-related offense. So just really, really quickly, my conclusions. I don't think that driver's license restrictions were passed with the intention of arresting all of those people and putting them into deportation proceedings. I also do not think that at the federal level, programs like Secure Communities were created with the intention of rounding up a lot of people who were driving without a driver's license, but it created the perfect opportunity for local jurisdictions who want to do that, who have this universal model, as was explained to us, to use traffic violations. It gave them what they needed to be able to round up all the people that they had wanted to do so for a while. So I'll stop there. Thank you very much.
Now we're hoping to have some good news. Pradine from the Vera Institute of Justice is going to talk about the program that she and others are developing. I gather it's still in progress at Vera for police practices and community liaison in immigrant communities.
Hi. It's a lot. That was a scary, it really is a scary world for immigrant communities and law enforcement. So let me actually just begin with this. Why are we talking about promising practices? We've heard about all of the programs, all of the initiatives that basically can in some ways allow law enforcement agencies to round up immigrants and deport them, right? That's all that we hear in the communities. What we know, though, is that the United States is increasingly diverse. These are the statistics that we know. What that means practically, though, is that law enforcement agencies across the country that are budget-strapped now have very diverse communities that they have to serve. As first responders, their role is to go into the community, to respond to a call, whether it be non-emergency or emergency situations. So although we've heard about a lot of the trends in federal and state statutes on enforcement, on the immigration enforcement, practically on an everyday level, they can't do that all the time. They just do not have the resources. These are people in their communities, and they have to learn how to respond. So they have to navigate culture, they have to navigate language, and we've been hearing a lot about community policing, about how law enforcement agencies across the country are really trying to engage their communities in order to help them do their jobs better. They don't have money, they don't have staff, they don't have resources, but they still are required to provide public safety. So the question is, how are they going to do that? How are they going to create these collaborative partnerships? How are they going to practically go in and do the jobs that, frankly, we all just need them to do on an everyday basis? We have these very real barriers. And part of the goals of the Engaging Police and Immigrant Communities project is to look at how law enforcement is dealing with these barriers. We hear about language, we hear about fear of law enforcement, and some of these, and all of these actually, work both ways. So law enforcement has a fear of the unknown, as much as immigrant communities that don't really know a lot about the laws of the United States, they have a fear of that unknown as well. The typical example, we heard a lot about the driving situation, the vehicle stops. The typical example of how all three of these play out in a traffic stop is this way. Someone gets pulled over, right? Language is first. We heard the example of they ask, license, registration. The person might not necessarily understand. Sometimes when the person is stopped in their home country, the response is once you get stopped by an officer, you get out of your car, you approach, you reach into your pocket to give money because you're supposed to bribe the officer so you can get on your way. That's a very cultural and very practical thing. And I think for some of us who have been in the United States for a long time, who have experience with driving, we take little things for granted, which then makes officers really nervous if someone is reaching in their pocket to provide money and the officer doesn't really understand. In some communities, they bow. And it's a very frustrating situation for the individual who stopped, who think they're doing the right thing, and law enforcement who's like, what is this person doing? Why don't they just give me their IDs? So in response to dealing with some of these challenges, very real challenges, I've just highlighted just three of them that I think we hear about or we it's easy to identify with in terms of the challenges. There are law enforcement agencies that picked up on these trends and picked up on, wait a minute, if every time we stop someone in this community and they respond the same way, why are we expending all of our resources to do the same thing over and over again when there are like level 1 offenses that we can be out there patrolling and dealing with? Why are we responding to calls for loud music when we, at this one location, when maybe it's like a cultural understanding, maybe they don't understand that if you play loud music at 3 a.m., even though you're celebrating the birth of a child and you have your cars all over the place, they might not understand culturally because it was never explained to them in any capacity that, okay, in this jurisdiction, this is not, people are going to call the cops when they hear this. So law enforcement agencies across the country that have picked up on these trends have been doing things, and by trial and error for some of them, because they didn't have a practical resource to go to tell them how to engage these communities. Keep in mind also that a lot of these communities, when we talk about fear of law enforcement, some of their fears come from experience with law enforcement in war-torn countries, come from a fear of law enforcement in places where it's really scary to be stopped by an officer or see an officer, period, right? So they figured out, some of these agencies have figured out things that are promising, things that have worked to deal with, to address those barriers, and then to work specifically with their communities. And I just want to preface, when we talk about immigrant communities in this capacity, we're not only talking about the undocumented immigrant. So I think there's this thrust to just talk about everyone who's undocumented. No, it's not just undocumented, it's everyone who's foreign-born, right? And anyone. And a lot of these communities, a lot of these immigrant communities are getting into these more rural towns in the Midwest through refugee programs, through a number of different outlets, so they may or may not have documents, who knows, but they're stuck in a place with law enforcement and they have to learn how to get along with them. So the point of this project, or the goal, is to take from these promising practices, from these agencies that have learned in some ways how to get it right? How to really work with these communities. And our hope is to create a report which will be released in August, late fall, which really just distills these practices based on a number of different indicators and provide podcasts and different resources for these agencies. So these are the 4 stages of our research project, and we're well on our way. We've begun writing. But the first one was developing these indicators, and it was a very structured approach in terms of figuring out what does promising practices look like in the context of law enforcement. The second phase focused on the national assessment, widely distributing a survey to about roughly 8,000 different agencies, telephone interviews, and then site visits. This process of figuring out what does a promising practice indicator look like, we looked to a number of different organizations that were actually using that language, best practices, in the law enforcement field. I want to stress, when we're talking about promising practices for law enforcement, we're really talking about things that are practical and on the ground. So the example of the vehicle stop, just practical, how do you deal with that the everyday? So these are the organizations that either had produced reports related to best practices or promising practices, or they have awards for certain promising practices within the policing community. So these are the 8 indicators that we kind of distilled from those organizations, from those reports, and in the interest of time, we'll only focus on the 4 that are highlighted in red. But this gives you a sense of the things that we were looking at in our agencies. The assessment, our main threshold question was, how are law enforcement dealing with these challenges on the ground? What are they doing? What are their practices? What are their programs? What are they practically doing to deal with their regular encounters with immigrant communities? The policies and programs that they have in place. Law enforcement, keep in mind, are very policy heavy. So unless there's a policy sometimes that tells them, or a practice internally that tells them how to deal with things, they simply do not know. It's a paramilitary organization. It's top down. They need to know how to do these. Language access is huge. Communication is the bread and butter of law enforcement agencies. If any of you have had any local encounter with an officer, sometimes you can be speaking English to them, but sometimes the lingo, it's not the right lingo, and it's hard to communicate, especially in very very emotionally charged situations, it can be very difficult to grasp the words that you need. Recruitment and training is huge, not only for the law enforcement officials, but also for the community members. So for example, think of the first time that you learned how to drive a car. Think of the first time that you learned when you can turn red someplace and when you can't. So training and learning what the laws are huge for community members. And also we looked at evaluation. So these are just some general demographics about the assessment respondents. So we had about 175 agencies, state, municipal police departments, sheriff's offices that responded fully to the assessment. And fully is very key, I realized. Range of sizes, they were from 3 to about 40,000, if you can guess who the 40,000 was. And a huge diversity in the immigrant populations that were served. So in phases 3 and 4, we used those indicators in the assessment to create sort of a weighted scale, and then similar to a college application process, we went through the agencies that scored higher on our scale, and then we really discussed the programs that they described and decided on 25 agencies to select for an in-depth follow-up telephone interview. That telephone interview was mostly done with executives and then the staff, the employees who were on the ground doing the work of the program or the practice they described. And these 10 are the final cohort of the ones selected for an in-depth site visit. The way we went from the 25 to the 10, in that in-depth telephone interview, I heard things like, oh, I've been at this agency for 17 and a half years. We have immigrant programs? And that selected that rate. So that helped us dwindle down the process. Things to consider though. So I keep mentioning how law enforcement agencies are budget strapped, right? So a lot of the work for some of the agencies that they were able to do with their communities, they no longer had a budget for it. And so what they had to do, they had to get rid of the formalized programs and then either get really creative, which we'll talk about a little bit with some of the agencies we did visit, get really creative in terms of either creating meaningful partnerships with other agencies, other law enforcement agencies in the area, or meaningful partnerships with the private sector or other social service providers so that they can actually still do the good work and also still do the very valuable public safety things that only a sworn officer can do. So this is our final, and you can see the spread of agencies, a lot in Florida. And we'll talk about a little bit about why. So these are the 4 indicators I'll focus on. So informed by needs assessment, what we mean is that they identified the problem and then they figured out a really practical approach in terms of approaching it. So they wanted to know what is the best way of approaching this problem now that we realize that we have an issue. What Brooklyn Park and Brooklyn Center noticed, I was talking about the loud parties. They noticed loud parties in the Liberian community. There was code enforcement issues because with the loud parties comes everyone driving to the loud parties and not knowing where to park their car and not understanding how to park their car, or that anyone would call the police instead of just, joining in on the party. It's a party. So what they did was they realized they were getting so many calls literally to the same areas for the same thing. And they caught on, this is not a public safety issue, this is an information gap. So the Joint Community Police Partnership focused on Brooklyn Park, Brooklyn Center, 2 other agencies that joined together basically to approach this problem, which has an educational component, staffs a community liaison at each department who goes door to door and speaks to the community. In Palm Beach, they received a grant that focused on the robbery trends of the Guatemalan Mayan community that were constantly getting robbed because of having large amounts of cash on their person. And because everyone understood or knew that this community carried cash, they became targets for robberies and other violent crimes. So Palm Beach, instead of just saying, whatever, they're likely undocumented, who cares? What they did was, they responded. They got a grant that specifically allowed them to work with that community and do things like teach about banking, teach about ways of saving money, things that the community honestly didn't know was available to them. And I think in a place like Florida, sometimes we don't necessarily think of law enforcement agencies reaching out, but they recognized that that was a critical problem, and they also recognized that robbers don't kind of work in a silo, so they perfect their craft there, and then they go out and continue more violent crimes elsewhere. Storm Lake, in terms of call for services, they noticed that they were getting particularly a large amount of calls from the immigrant community, so what they did was they decided to have 4 mobile units in a particular area where the calls were the highest. So they brought the law enforcement to them, and they didn't do it in a scary capacity. They basically brought out their mobile command, brought out flyers, crayons, things that I think sometimes we take for granted or don't think about law enforcement doing, but it allowed for people to just approach and say, oh, what's going on? Like they were there, they weren't arresting anyone, they were just there to see if anyone wanted to come to them and ask questions, and it was a really casual environment that ended up being pretty beneficial for the department. Meaningful partnerships, I mentioned, Clearwater and Everett Police Department are 2 that really exemplify this in an interesting way. So they both partnered in a way to provide a kind of holistic social services for the immigrant communities that they were servicing. So the Hispanic Outreach Center is literally like a center. It houses an officer, a mental health counselor, periodic legal services comes in, and with Everett Police Department, they partnered with La Comunidad, which is a social service generalist center that works in concert with their domestic violence division to really just build the gap and make sure that they're reaching the women who are from the immigrant communities and afraid and don't know that they can call the police if they need to. Maximizing resources, again, with the same idea of a little bit with building partnerships, using or relying on public and private sector assistance, volunteers in public services. They provide language assistance for the department, which is very beneficial, especially on very tight budgets. Lastly, training for law enforcement community. Tulsa picked up on the fact that they can't make their entire staff bilingual as much as they would like to. So what they did, they created this survival Spanish. The 27 phrases, it's not intended to make them bilingual. It's intended to make the community members comfortable in hearing the language. So when they hear manos arriba, right, they hear that, and that at least allows the officer to control the situation until someone who is able to interpret comes in. The way these officers get trained to use their phrases is that the same way they get trained to use their tactical abilities, they go into a room in order to graduate, they go into a situational room and everyone is speaking Spanish and everyone is doing all sorts of crazy, all in Spanish. And they need to use one of those 27 phrases or enough of them to control the situation only. And it freaks some of the cadets out, but it's practically on the ground in Tulsa, on any given night in a particular precinct, that's exactly what's going to happen. So it provides them with a very realistic view. For the community members, Orange County and Chelsea, they took to explaining what law enforcement does and to explaining what the crime trends are that impact the community. That specific aspect Orange County Sheriff's Office does. So it tailors, for example, in the Hispanic community that was dealing with a lot of these notarios or fake immigration attorney bodies. Like they provided a service, they provide these academies that go in depth on how to identify an actual immigration lawyer, what the difference is, what a notario means in the United States. So that's a happy part. And I guess we'll turn it over for questions.
Fine.
Here's my
Thank you.
You're welcome.
I'm going to be very brief so that we have some time for a Q&A. I think this was a wonderful variety of issues to deal with. Judy Greene calls it widening the pool of criminal illegal aliens. It's essentially a construction of enemies. And I think, in the 1970s, it was an ethos of social work that drove the net widening. Now it is a combination of retributive perspectives, which have dominated criminal justice in the last 30, 40 years, and federalist opportunism. I'm struck by how many of these presentations and a lot of the writing that's been done deals with local and state efforts to dominate the debates and the immigration enforcement. Couple of comments on specific papers. I liked Judy Greene's approach very much in illustrating the interaction between political leaders' positions and the public's attitudes, which drives policy. It's often, is restriction what the public wants or what the political leaders tell the public it wants? And I think it is very interactive, and that Judy's paper does a very good job of presenting that. Juan's paper interested me very much as the sort of presentation of secure communities as almost a substitute programmatically and politically for 287G and its failures and its decline. Secure community seems to be covering all jurisdictions, taking over policing function that was to be deputized to cops for 287G. And I think his point that it's different in that it doesn't follow a proactive decision by state or local actors. It is imposed upon the state and local actors. And I think this makes it both an instrumental force, putting this policy into local jails, but also a symbolic directive, which, however, is national, a message of exclusion. With respect to Michelle's paper, by the way, another paper which has more than she could present in this very brief period, and so I urge you to be in touch with her if you're interested in knowing more. To me, the construction of the enemy that I mentioned before is particularly blatant in the legal endorsement of criminal traffic violations, which sounds to me like a contradiction in terms, but as a category of behavior that makes its perpetrators deportable, and of course as a level 1, as she mentioned, a level 1 offense. I have personal knowledge of another consequence of the ban on driver's license for undocumented immigrants. I can tell you that in Suffolk County, New York, Suffolk County, at least, immigrants are driving anyway, and they get legal residents, often, not always of course, but they often get legal residents or citizens to purchase cars for them, a situation that can give rise to exploitation by the owner of the car with respect to paying for the cars and the insurance, or on the other hand, to vulnerability of both the drivers and the owners of the cars if immigrants are involved in accidents or are picked up for traffic offenses. So I just wanted to add one little bit of my own work to the understanding of how this works. And I sort of disagree that the ban on driver's licenses is intended to send a message of exclusion. I think there is, of course, that, but I also think it's a disciplinary measure. If you get millions of people who cannot drive or who are not supposed to be driving and who drive anyway, it's another way of ensuring that undocumented people keep their heads down and their noses to the grindstone and provide the kind of work that we all know we need from the immigrants that we now have. Finally, I think Pradine's good news is in fact very, very good news. I'm excited by it, but I'm wondering about all those communities that weren't selected. My experience is that in small towns, there is such a tension about this issue and such a lack of resources to develop meaningful programs that I think probably cities are better equipped to do this in general than small towns. And I would ask about the variation. I thought it was wonderful that the program is looking at the variation in programmatic emphasis. I'm very interested to know what the variation is in terms of the evaluation of the effectiveness of these programs, and I assume that comes next or soon. So, for instance, how effective, I'm interested in knowing how effective are these community liaisons that your paper mentions. So I think we should move to the Q&A. We have a lot of very valuable information here. Judy, Pradine, Michelle, Juan are all available to answer your questions.
So just because of time constraints, we're going to take 2 questions at this point. And I'm going to bring the microphone around. So any questions for the Procedural Justice panel?
Oh, yeah. Hi, thanks so much for a series of really great presentations. I guess my question is mostly directed towards Michelle, but other people as well. It's specifically about the NCIC database. I remember a number of years ago, there was a paper that was written that showed how I guess I was wondering if you can clarify what kind of immigration-related information is put into the NCIC database now. I remember there was a time that it was disproportionately reflected outstanding warrants on people of particular national origins, and I was wondering if that's still the case or if that's changed. If you can give a little bit more information about that, that'd be great.
Sure. I'm looking it up just to make sure that I get it right. It has absconders, people who registered or who failed to register for NSEERs. Okay. Persons previously convicted of a felony and deported, persons allegedly subject to a final deportation order, which is absconders, and the third is persons allegedly in violation of the NSEERS program. So those are the 3 categories. There have been efforts to include more categories in NCIC. That was part of the CLEAR Act, so Congress has tried to legislate additional categories. These were not added legislatively, they were added administratively. But there haven't been any new categories added since those 3.
One more question? Sorry.
This is directed at Juan. Curious about the level of penetration of secure communities at this point. I believe by 2013, the nationwide participation is being sought, and how much resistance there has been among particular communities. I know a number of states have refused to honor ICE detainers, a number of cities rather, and some states are not participating. So if you could say a bit about that. Thank you.
It's a really good question. There has been a lot of back and forth and a lot of controversy over whether local jurisdictions have to use the fingerprint submission program and whether they then have to cooperate with ICE if there happens to be a hit. There's been a lot of discussion over, in some states, can we just, give you the information but not get anything back so we don't know what you're doing? And there's been, a lot of conflict around should we even have the option to opt in or opt out of this program. So that's still ongoing, and Michelle would know more about that. In terms of penetration across the United States, 79% counties now have ESCOM live as of Tuesday. So it is looking like it will cover 100% of all counties by 2013. Not sure when in 2013. What's interesting, and I don't know how much to read into this, if you look at states that are already 100% covered and where those states are versus states that curiously have far less. So Illinois, for example, large sections of the state don't have ESCOM yet, and pretty much every surrounding state has the program. Is that chance, given that Illinois is such a huge immigrant receiving state? I don't know. There are some states that were from the early days. If you follow when the programs are activated, it looked like they were